Good morning, Mr. Kramer.
Good morning, Your Honor. May it please the Court. I'm not here to deny that my client committed misconduct and violated various rules of professional conduct here. I'm not here to justify his actions. But this Court must still insist that the State meet its burden of proof to support the sanction sought in this case. And I will argue principally three things. First, that the State failed to prove fraud, deceit, or misrepresentation. Second, that it cannot turn a negligence case into a disbarment case. And third, that this case is quite similar to those meriting an indefinite suspension with a right to reapply for anywhere from 60 to 90 days. In this case, the State has proven what my client, Mr. Mahone, admitted to long ago, that he failed to maintain adequate records and monthly reconciliations on his escrow account. As Ms. Lawless herself advised the lower court, this was not charged as a theft or misappropriation case. This case isn't about did he steal money. There's no evidence of that. As Ms. Lawless indicated at the conclusion of a very, very brief transcript in what was a very brief hearing below, this was charged essentially as a negligence, or what she termed extreme negligence and mismanagement of a trust account case. This is definitely not a case of dishonesty, fraud, deceit, or misrepresentation. In fact, the lower court, Judge Callahan, found that my client acted without malice or personal gain. And nonetheless, despite that, we find in proposed findings of fact and conclusions of law a requested finding that he violated Rule 8.4c, that there was some type of deceit or misrepresentation. It's the first time there's ever any charge or indication that there was a violation of that rule. But what's most important here is that we don't have any facts to back that up.
Mr. Kramer, the Attorney Grievance Commission notes that there were 3 prior disciplinary actions. Is that something the court should consider in looking at a pattern of problems with representation?
I don't think so, and here's why. But, of course, I'm also a realist, and I understand that the court is not going to turn a blind eye to a disciplinary history. But what Judge Callahan had to do below, and it's very clear and it's specified in Rule 19-727D3, she has to make 3 findings. She has to find, third, she has to find aggravating and or mitigating circumstances, or render findings to that effect. She actually rendered no findings at all on aggravating or mitigating circumstances. In fact, not once in her opinion of findings of fact and conclusions of law is there any mention of the disciplinary history. Now, I realize it exists. We're not denying that it exists. And it was admitted into evidence. It's certainly in that large loose leaf to my right. But if you're going to take aggravating circumstances into account, let's also take some mitigating circumstances into account. Namely, what Judge Callahan did find, and perhaps the only time she really departed from the script that was provided in the proposed findings of fact and conclusions of law, is that there was no malice or motive for personal gain. Basically, as we know from this Court's decision in Dunier, an absence of dishonest or selfish motive is a mitigating factor. So if we're going to take aggravating factors into account, we need to take mitigating factors in as well. Another thing that Bar Counsel proposed below was that there was a lack of remorse, a complete lack of remorse. There's absolutely nothing to indicate a lack of remorse on the part of my client, and I can personally say that he's very remorseful about the fact that he is back before you.
Well, I think you...
I'm sorry.
Judge McConnell, go right ahead.
But, you know, as we usually say, the sanctions for protection of the public, not to punish. And
correct.
This is the 4th time through for Mr. Mahone.
And in that respect, Your Honor, it is very much like a case that my opposing counsel cited in her recommendation, which would be the Sperling case, 2013. There you have a situation where there had been previous suspensions. There had been a whole history of problems and prior discipline, prior suspensions and so forth. The bottom line is that you have to first and foremost look at the conduct and what's been proven, not what the state would like to have proven but didn't. What are we talking about here? If we're talking about a case of theft for which we have no evidence whatsoever, if we're talking about a case where clients lost money or something of that kind, different story. But what we have here is a case of, as Bar Counsel indicated, negligence. And so to protect the public, yes, this Court has previously found that a suspension can indeed be used to protect the public in these types of cases. And we also know that once suspended, even if there's a right to reapply in 90 days, or a year, or 6 months, or whatever this Court deems appropriate in its judgment to protect the public, that reinstatement is not assured. And there may be conditions upon that. So I do believe that a sanction below disbarment, which is reserved for the most egregious cases of theft and deceit and misrepresentation, that something of this sort can indeed protect the public. And that's, I think, the key here.
Going back to 8.4c.
Yes.
It seems the premise for Judge Kavanaugh's holding or conclusion is that Mr. Mahone created negative balances in his trust account for individual clients and gave no explanation for those negative balances. Do you agree with that?
I agree that she found negative balances, but if I may address that, it's never been proven. And here's why. And if Your Honor will bear with me, taking a look at the very last exhibit in that loose leaf, Exhibit 30, which is the supposed recapitulation provided by Charles Miller, an investigator for the Commission, who, by the way, was the sole witness called in this case. I don't know how he was a witness. He certainly wasn't a fact witness, and he was never qualified as an expert, never offered any opinions. What this supposed recapitulation does is raise lots of questions. It answers none of them. It does not, for example, truly find a negative balance. It asks questions like, was this an earned fee? Explain why there appears to be remaining funds, or why there appears to be a negative balance. They've got to do more than have investigators' notes that raise questions. They've got to answer them with clear and convincing evidence. And if you'll look at the second page of Exhibit 30, and I'll just use this as an example to address Your Honor's point. If you look at Hickman at the very top, it says, please explain why there appears to be remaining funds for this client. If you look at it, and by the way, whenever there is an overdraft, and in this case there was an overdraft of $86.48, what Bar Counsel does automatically, I don't even think there's human intervention anymore, is spits out a letter to the attorney and says, please explain why there's this overdraft and give us the last, this month and the 3 prior months of escrow records so we can take a look at this and get a snapshot of what we're talking about. And that's all they ever did in this case, because it was from November 2013 on. They didn't go beyond that, or, prior to that November 2013 cutoff. So if you look at Hickman, you'll see November 8, 2013, it seems like the world started at that date on that matter with a $500 check written to Mr. Mahone. What is the notation? That there's a negative balance at that point of $500. There's a negative balance of $500. What Bar Counsel needs to do to prove a negative balance is go back further in order to show that. Because if you look at what was tabulated for negative balances by the lower court, you'll find that there was a negative balance that totals, by my math, $11,414.79. If you look at opinion page 3, that, I understand, Your Honor.
No, go ahead.
But then if you look at the earned fees and the balances remaining, which are tabulated at page 4 of the opinion, You have earned fees of $2,273.75 and balances remaining, or like an over, I guess, an account having too much money, of $2,992.31. Well, if you do the math on that, you would find that this snapshot would suggest a shortfall, not of $86.48. You'd have a shortfall of $6,148.73.
All right, Mr. Greenmer, I think the court is following your argument. I'm going to ask, if you don't mind, to tie your argument back to the exceptions that Mr. Mahone filed, and if you could just run through, we need to have clarity on what your continued position is on each of these 7 exceptions, and then the catch-all exceptions to conclusions of law that are based on these factual exceptions.
Yes,
So,
and I should say preliminarily, Your Honor, that Mr. Mahone did try to supplement some of those, but I would be happy to provide some clarity here.
yeah, so let's begin at the beginning here with
Okay.
exception number 1. Do you still maintain that he failed to respond to, that he didn't, that there is an incorrect finding on the part of the court, the hearing judge here, that respondent failed to respond to letters?
Well, I do
Or
think it's
bar
been
counsel.
incorrect.
How so?
In the sense that my client on March 28th of 2014 provided bar counsel with a letter explaining the situation, providing 7 attachments with all the records he had at the time.
So ahead of these 2 letters? You said March of 2014?
Correct, and that's Exhibit 3.
Okay.
And it actually enclosed, although it's not, I think, in the record that was presented here, but it had 7 attachments with a plethora of information about the account.
So are you making the argument then that he anticipatorily responded to letters that came to him?
Well, no. I
later?
guess what I'm making the argument of is that I definitely understand why bar counsel would be dissatisfied with the amount of information provided. In part, that dissatisfaction stems from the idea that he didn't keep the records that he should have kept. So it's not exactly easy to come up with something you haven't maintained in the first place. But there were also some unclaimed letters. I just don't think that a finding that he in some sense obstructed the investigation is accurate, because quite the contrary, he answered every question he could to the best of his
He
ability.
seems to be arguing in the exception that because the communications, he changed offices. And
That's
that
right.
was
And I
essentially-
recognize, and he recognizes, that that's
Okay.
his fault.
All right.
He has to do that. But it's a question of, was it willful? I don't think it was, and if you look even at the discovery in the case, he admitted the sound majority of requests for admissions. He answered every question in deposition. I think he was very candid, and part of the reason is that's why I can't really deny a lot of things.
So with regard then to the exception number 2, pretty much is your argument or your response essentially the same?
It would be the same, Your Honor.
Okay. What about number 3?
I don't believe we'll maintain that exception because he did in fact indicate that there were certain funds that were earned that were left in.
Now, your argument today has focused, at least, and you'll correct me if I'm wrong, on number 4.
That's correct, because I don't believe that the record facts do indicate that there were
Okay.
true negative balances, or at least if there were, it certainly wasn't proven.
Number 5, Mr. Mahone writes that this finding is partially erroneous, that respondent deposited or returned attorney's fees.
Again, similar to the commingling issue in that there may have been some mistakes made in that respect. So it would be a scenario where in a couple of instances there may have been too much money put into escrow as opposed to not enough.
What about commingling? That seems to be well, that's back to number 3. You're conceding the commingling.
I think so.
Okay, all right.
I think so. And it's a question of sloppiness, as counsel noted, a question of inadvertence and negligence.
Wasn't there a withdrawal of $1,500 to cash?
$1,500 to cash.
From the escrow account?
There may have been, And that's certainly improper.
What's the explanation for that?
There isn't a good explanation for that.
Okay.
There isn't. The key question here isn't the fact that there were infractions. There were infractions, and we recognize that. The question is, what do we do about it? And the question is, what isn't it? It is definitely not a scenario of fraud, deceit, or misrepresentation. I mean, not one client came forward to testify that they were cheated in any way. And we all of us lawyers in this room, we know how to prove theft. We know how to prove intentional misappropriation. And we don't do it on the 50-page transcript that was recorded the hearing below. We don't do it on the basis of notes that provide the questions our investigators have without digging deeper to figure out whether there are answers that show anyone was cheated in any way.
Are you saying that we never disbar for gross negligence that has been repeated?
Well, I don't know that it's been repeated in the sense that I recognize while there was a disciplinary history, it was of a different type of issue. And there wasn't a finding below connecting that as an aggravating factor that ought to be taken into account in this instance. What I am saying, however, is that if we are going to be fair and we are going to respect what this Court has done in prior cases like the Sperling case, that an indefinite suspension with a right to reapply after a period of time is more appropriate. And that's why I believe the appropriate sanction ought to be a suspension with the right to reapply.
Okay, we will let you know how much of your remaining rebuttal time
Thank
is
you.
available to you when you stand up again. Ms. Lawless.
Good morning. Lydia Lawless, Assistant Bar Counsel on behalf of Petitioner. While this case may have began with an $86 overdraft notice in February of 2014, the story really begins in 1997. In 1997, Mr. Mahone received an indefinite suspension with a right to reapply in 3 years. That misconduct was a result of failing to pay withholding taxes for numerous tax years. Additionally, the misconduct in that case was an 8.4C violation for opening and using a bank account in his brother's name after the IRS had asserted a lien over his other property. Mr. Mahone was reinstated in 2000. The findings of the trial court in 1997 were that what is clear is that the respondent did not pay taxes and he did not file the forms through a combination of his financial picture, his financial management, and a utter disregard for accounting practices. That's the premise of the indefinite suspension with a right to reapply in 3 years. When Mr. Mahone was reinstated in 2000, as part of his reinstatement, he was required to take a course on professional responsibility. He completed that course and was reinstated in 2000. In 2005, Mr. Mahone consented to a reprimand by this court for failing to respond to Bar Counsel in violation of Rule 8.1b. Rather, the failure to respond to Bar Counsel was in 2005, and the consent to a reprimand was in 2007. I apologize. In 2009, 2 years later, the respondent engaged in additional misconduct when he failed to safekeep a third-party lien on a settlement proceeds that he received and deposited into his trust account. As a result of that misconduct, in 2012, he agreed to another reprimand by consent in this court for violations of Rule 1.15, the safekeeping rules, 8.4d, conduct prejudicial to the administration of justice, and Rule 1.1, competence for his failure to competently maintain his attorney trust account. In 2014, Bar Counsel received an overdraft notice. As a result of our investigation, we proved that the misconduct dated back to the earliest date of the bank records that we received, which was November of 2013. The only appropriate sanction in this case is disbarment. Mr. Mahone has demonstrated that he is either unwilling or unable to conform his conduct. He does not take his responsibility to maintain and safekeep third-party funds seriously.
What is your response, Ms. Lawless, to the argument that Mr. Kramer puts forward this morning, that essentially this is negligence, and the failure to keep the books properly. I mean, do you agree, do you accept the premise here that none of this was done with malice? I think we have Judge Callahan's finding that it was not.
We do
that
have
it was
those.
It was not dishonest.
I understand, Your Honor.
Okay.
We do have those findings. And one of the problems that we have in these record-keeping cases is without the proof, we can't charge intentional misappropriation. We can't prove the theft where there's no record of whose money is deposited in the trust account, whose money is withdrawn, what withdraws in cash, electronic transfers, or by check that to the respondent that are all present in this case, which individual client ledgers they attach to, because there aren't records. So because of that, we don't charge it as theft cases. We did not charge a violation of Rule 8.4b, which is criminal conduct in this case. What we charged was a violation of Rule 8.4c. There was misappropriation. The respondent used client funds to pay other clients' matters. That was proven. I cannot, and I did not prove that the respondent misappropriated for his personal benefit any funds, because the records don't support that, because of the lack of record keeping in this case. So I think that the 8.4c hinges on that there was misappropriation. I think that there is an extreme amount of aggravation where all attorneys are certainly presumed to know and appreciate the Maryland Lawyers' Rules of Professional Conduct. In this case,
Are you
yes,
saying that if there had been record keeping, you would have been able to prove fraudulent intent and misappropriation?
No, Your Honor. I'm saying that we couldn't make a determination one way or the other. That we may have been able to charge it, but we were never able to reconcile the attorney trust account. Mr. Mahone was never able to provide us information, documentation in those numerous requests during our investigation as to whose funds he was withdrawing when he withdrew $1,500 in cash.
So you don't have any reason to believe that he took those funds for himself?
Well, he did take the funds for himself to some extent, Your Honor, because he wrote checks to himself without any associated clients. But that doesn't necessarily mean that it was intentional misappropriation. It may have been earned attorney's fees, but due to his lack of record keeping, he could never explain it to us.
Ms. Lawless,
Yes,
another
Your
point that Mr. Kramer has raised is that no clients were harmed in this case. What you've described as sort of a sleight of hand shifting of funds between clients, but it appears that eventually the funds in the trust account were earned as attorney's fees, and that none of the clients were harmed or required the repayment of fees. In the prior cases, are there specific instances of clients being harmed, or is this intentional or negligent shifting of funds in the
If I could
trust
address
accounts?
that in two parts, Your Honor. The first is no clients complained that they were harmed, but I would submit there's no evidence that the clients knew that any of their funds were misappropriated. So I think that the premise on which the statement that Mr. Kramer made is not supported by the facts. I mean, the clients didn't know. They entrusted their funds to him, and he used their funds for purposes that were not authorized in violation of the business and occupations profession and in violation of the rules of professional conduct. So clients were harmed in this case. They may not have known, but they certainly were harmed. In the previous disciplinary cases, Your Honor, the first case was a result of failure to maintain and then pay withholding taxes. So it wasn't client matters. I guess it was employees that were harmed with any penalties that may have been associated with that, as well as both Maryland State and the federal government. And then in the second second trust account case, that dealt with a lien that was asserted by I believe it was a prior counsel that had asserted a lien for attorney's fees when Mr. Mahone took over the case. So it wasn't a client that was harmed, it was a third party. But the rules of professional conduct, specifically 1.15, cover client and third party funds. So I don't think that that's a distinction with much of a difference in this case, quite frankly.
A couple of questions.
Yes, Your Honor.
Preliminarily, do you have any objection to respondent's motion for leave to file supplemental?
None.
All right, thank you, counsel. And if we didn't have the prior incidents of professional misconduct, would this be a disbarment, in your view?
No, Your Honor. And it really is the prior discipline, and not only the prior discipline, the extent of the prior discipline for these exact same rule violations. Exact same, both the failure to respond to bar counsel and the failure to safekeep funds. And so while it may be that if this were the first time up or even the second time up, that an indefinite suspension with some sort of right to reapply where the respondent could demonstrate that he has conformed his conduct and appreciates his obligations, that may be the appropriate sanction. But in this case, I think it was in the Margolis opinion where it's 3 strikes and you're out. I mean, how many opportunities do we give attorneys to take client funds and to mishandle them?
Well, this is the second time that he's had a problem with his trust account, right?
The third time, Your Honor. The first was the withholding taxes.
Yes.
The second was the lien for the prior counsel, and then this is the third overdraft.
So the withholding taxes are a trust account violation?
It's a safekeeping violation, Your Honor.
Okay.
So it's a duty to safekeep funds that are not the attorney's own
And is
funds.
that's the one that occurred in 1997, right?
Correct.
Do you take into account the passage of time? I mean, that was almost 20 years ago.
I think it's taken into account where there isn't this pattern in practice of continual disregard for the obligations. If it was one prior sanction in 1997 and Mr. Mahone had reformed his conduct and an overdraft came in and he promptly and completely responded to bar counsel and was able to reconcile the account, no, I don't think we would be asking for a disbarment. But this account still hasn't been reconciled. We have no idea whose money was withdrawn when he withdrew $1,500 in cash. We have no idea whose funds were taken from his trust account in the $2,000 electronic transfer and the $1,000 electronic transfer. We have no idea whose funds were used when the respondent made a $100 donation to his church from his attorney trust account. So all of those things need to be taken into account. And while Mr. Mahone certainly had an obligation or an opportunity to present mitigation to the court below, compelling mitigation would have been a reconciliation of this account. And that hasn't been done. So there is no evidence that has demonstrated to bar counsel that Mr. Mahone is fit to hold third-party funds.
Another question. With regard to the responding to bar counsel, was that he never responded or that he was late in responding?
It was a combination of facts, and they're outlined in the judge's findings. But essentially it was initial late and incomplete responses, and then there was a request for a series of extensions of time to respond, which were granted, followed by more incomplete responses, and then a complete failure to respond. So it's sort of all the different permeations that could be envisioned.
Tell us about the last of those, the complete failure to respond.
Your Honor, there was, and as to the change of address and the return, if I could just address this while it's on my mind, the judge did not make a finding that the last letter, there was a December 2015 letter that was sent by certified mail to Mr. Mahone's old address, which was returned to bar counsel, undelivered, and that is not part of the findings for an 8.4b. So the failure to respond was the original overdraft came in February of 2014. In March, Mr. Mahone provided a 10-day late and an incomplete response. There was a letter sent out April advising Mr. Mahone that his response was incomplete and requesting the additional information. No response was received to that.
To which letter?
The April 10th, 2014 letter.
And what was the additional information?
The client ledgers and the deposit slips.
Okay,
so
now
the-
if he didn't have those, how could he have provided them?
Well, his obligation was to maintain them, Your Honor, under the rules of professional conduct. The deposit slip, certainly he could have obtained from the bank, but the client ledgers are something that he's required under the rules to create and maintain for this period of time.
Did he give an answer to the letter that essentially said, I don't have the materials that you're asking for?
He did not, Your Honor.
So no answer at all?
There was no response. And then there was a subsequent letter from Bar Counsel in November of 2014, again requesting a response in December. In December of 2014, Mr. Mahone provided again the December letter, nothing was provided in response to the November 18th letter. The December letter was sent. That's the one that was returned.
I'm sorry, I thought we did April 10 and then December.
November. There was a November letter forwarding again the April, or not forwarding again, but requesting the same information that was requested in the April letter. And then there was no response from to the November letter.
Ms. Lawless, am I right that there's no exception to the hearing judge's finding about the failure to respond to the April 10th, 2014 letter?
I believe that that's correct. It's a little bit hard for me to flesh out because the exceptions were so general. But there is no dispute that the December was not a failure to respond because I didn't prove that he received that letter. But the April failures and the November failures, as well as the initial failure to timely and completely respond, are all proven and evidenced in the record.
Just a question about the hearing judge's finding on page 6 at number 12. The hearing judge noted that the respondent answered some questions about 4 transactions during his deposition. What was that about? Did these questions have to do with the negative balances?
That's correct, Your Honor. In a few weeks prior to trial, I had the opportunity to depose Mr. Mahone, and I asked him for much of the information that had been requested previously, which is tell me whose money this is and whose money you're withdrawing. And at that time, our investigator, Mr. Miller, had done a preliminary account analysis based on the bank records that we received after a subpoena was issued in January of 2015. And Mr. Mahone was able to answer some of the questions related to individual transactions or individual client ledgers. And following that deposition, we went back and our investigator updated the summary to reflect the additional information that Mr. Mahone was able to provide. So the evidence that was produced at trial included it was the most updated based on all the information that we had received from Mr. Mahone. For example, we had one client had 2 different names, and at his deposition, he was able to say, this is not 2 separate client matters, this is one client matter. So we then revised the ledger summary to reflect that testimony. So essentially, he was given every single benefit of the doubt in the transaction summary and the client ledger summary that was provided to the court. He had every opportunity to respond. He had every opportunity to provide any information that he wanted, and he failed to do so.
Early in Mr. Kramer's presentation this morning, he challenged, I guess it was an express determination, I can't find it offhand, by the hearing judge that there was no showing of remorse. But I heard Mr. Kramer say that, of course, his client is remorseful. What do you make of that, if anything?
I don't think that there's anything to be made of it. There's been no demonstration of remorse. There has been no effort to fix what he's done. The account hasn't been reconciled. He hasn't taken a CLE program demonstrating that he's up to date on the record-keeping practices. So to say I'm remorseful, it's not in the record. It's not reflected in his testimony either at trial or in his deposition below. Is he sorry he's here? I believe that 100%. But is that remorse? Is that remorse that the court should consider as a mitigating factor? I don't believe it is, Your Honor.
Is Mr. Mahone's his trust account, is it capable of being reconciled at this point, or you've lived with this, so what is your sense of it?
Not by us, not with the information that we have and the lack of information that we have.
Counsel, it appeared that an account analysis was one of the important themes that was advanced below the circuit court, and you indicated that if Mr. Miller testified regarding that, it appeared that Mr. Kramer was challenging the testimony of Mr. Miller because he was not qualified as an expert in that regard. Can you address that?
I can, Your Honor. There was no objection that was made below, to the best of my recollection. Although now that I think of it, he may have objected to it. Mr. Miller was not offered as an expert. He was offered as a fact witness, and essentially what he did was create a summary of the evidence. There are two relevant trial exhibits. The first is a account summary, which is literally just creating, on this day there's this transaction, this day there's this transaction. So basically just recreating in a different format what's contained in the bank records. No analysis is done. It's a data input process. What you do, and what Mr. Miller did, and what the testimony in this case is that after you have a general ledger, you create individual client ledgers based on that information, and you sort it by client names or other identifying factors. So, for example, on the general ledger on January 1st, there is a deposit from a check from Joe Smith. And then on March 30th, there is a payment to Mr. Mahone, and in the memo it says Joe Smith. The facts, the undisputed facts in the bank records are that those two transactions exist, and we tie them together. So then we just reorganize the information contained in the general ledger into individual client ledgers. And so,
but the ability to gather that information and organize it in some demonstrative fashion, that could have been accomplished by you. It could be accomplished by any member of this bench. So I guess I'm trying to distinguish why Mr. Miller, what expertise did Mr. Miller have over anybody else that is capable of performing that task?
well, that's exactly the point, Your Honor, is that there was no expertise. I mean, he's a fact witness, so it's just a summary. It's just a summary of the evidence and his observations about what the evidence shows. I mean, his job description includes this. So, I mean, we could get into his background training experience, but quite frankly, it's not relevant for what his testimony was. It was, I created this summary. This is how I reorganized it. These are the questions that are raised. These are the individual ledgers that were balanced. These are the ones that I haven't been able to balance. And it's the way that we have always proved these cases and tried these cases, that without the necessity of expert witnesses. I don't think we've ever had an expert witness for bank records, maybe once or twice, but none that I can recollect.
Was it argued to the hearing judge by Mr. Mahone that the lack of bar counsel's presentation of an expert on all of this somehow renders, makes legally insufficient your presentation on this point?
I didn't look for this in my review for today, and I sort of heard this attack on the evidence the first time this morning. My recollection is that some objection was made, but I'm not positive. The exhibits were admitted as summaries of the evidence.
You said there were two relevant exhibits on this point, and they are what? Is 25 one of them? I heard that Mr.
They
Kramer
are
30 and 25 maybe?
the client ledgers, Your Honor. I think are 29 and 30.
All right.
I can't put my
Okay.
hands on them at this exact moment.
All right.
Ms. Lawless?
Yes.
The respondent argued the Sterling case. Do you wish to comment on that?
The Leonard Sperling case, I think it was, there are many Leonard Sperling cases. There was a Leonard Sperling case where it was an indefinite suspension, my recollection, for negligent or egregious mismanagement of an attorney trust account. I have not reread that case for argument today. My recollection of that case was that there was a reconciliation done during the disciplinary process, and other steps taken by him to bring his practice, his record-keeping practice, into within the requirements of the rule. Is my recollection, but I may be thinking of a different case, Your Honor.
I think he cited it. I've been looking for it, but I saw it earlier, now I can't find it.
Uh-huh. There is a reference to it. That's all right.
All right,
We will find it.
If there are no other questions, I would ask that the court overrule the exceptions filed by the respondent and disbar Mr. Mahone. Thank you.
All right, thank you, Ms. Lawless. Mr. Cockrell, how much time does Mr. Kramer have remaining? Thank you.
Mr. Kramer, can we start on the topic of remorse, which there were a number of questions asked to Ms. Lawless. I note that in the supplement that the court has accepted, that there's an accountant now helping with
That's correct.
the law office. Can you just comment generally on remorse and maybe office practices, generally in a law office? It's not the attorney handling billing, and
Exactly.
the attorney has the ultimate responsibility, but is there an office practices issue?
Well, that's exactly right, and God help me if I didn't have an office person that I could rely on to help with all this math. And that is something that Mr. Mahone has now, and indicated that he did have after this all became apparent. So I don't think there's a lack of remorse. And by the way, I should mention that I don't think the judge found that there was a lack of remorse. It was proposed that the judge find a lack of remorse by Ms. Lawless. I don't think there's any evidence to that effect at all. In fact, he does seem to take very seriously his responsibility. He's certainly not happy to be back here in front of you and doesn't want to ever be back again. And he wants to make sure that these things are taken care of. So that, I think, shows that he does recognize the gravity of this.
Mr. Kramer, what's the remedy?
The remedy? The remedy for, in moving forward, obviously you can't change the past, but in moving forward is need to work with professionals who can assist in areas where he, as a lawyer, is admittedly weak. And that is one thing that needs to happen upon his reinstatement. He needs to demonstrate to you, upon a motion for reinstatement, that he is indeed capable of returning to the practice of law and abiding by it.
How long is it going to take to remedy this account, reconcile?
Well, I think that's a matter in process already. That's something that's not yet complete. But let me, if I may.
You don't know how long it's going to take?
Do I know how long it's going to take? I don't know.
Okay.
And I've been retained late, and it's probably an answer I ought to know. But I don't, so I can't represent otherwise. What I can say is this. Ms. Lawless seems to want to shift the burden of proof to my client. That's not the way the rules read. She said, like, we can't prove theft because in order to do that, we need better records. We didn't have better records, so we can't prove it. It's his fault, therefore. There has been no showing of misappropriation, no showing of shifting of certain expenses from one client to another. And let's face it, if the objective is to protect the public, and that is indeed one of Bar Counsel's functions, and I cast no aspersions, they do it quite well. But if that's the case, why respond to this court by saying, well, these clients probably don't even know that there was a problem? Wouldn't you, if your job was to protect the public, contact clients and say, hey, let's take a look at your accounts. Let's see if you lost any money. Why would you leave them in the dark? Why wouldn't you subpoena records that go back before November of 2013? If what you want to do is determine whether anyone lost any money, wouldn't you, as Bar Counsel, do that? And isn't that exactly the burden of proof, of clear and convincing evidence that's on the petitioner in this case? So I think it's a bit disingenuous to try to shift that burden to my client. My client had the burden of producing good records. He wasn't able to meet it. He didn't meet it. And that's a violation that needs to be sanctioned. And we understand that. and are remorseful about it. But Ms. Lawless understands. He lacked the records, therefore we couldn't do what we'd ideally like to have done.
Therefore, they did not file an 8.4B charge.
What's that?
They did not, I don't think Bar Council filed an 8.4B charge, did it? Did he? It? Count the commission? They? She?
I don't know if it, they, or who did
Well,
that.
I thought I heard that today.
Well,
The
this
reason
was
they
not
could
charged as a
establish.
theft case.
Exactly.
Certainly not. And because there's absolutely no evidence of that whatsoever, clear and convincing or
Well, I
otherwise.
think everyone in this room, the 9 of us.
But it's a bit of a bait and switch to say, we recognize this as a negligence case, and then to propose findings of fact and conclusions of law which suggest an 803C violation, when there really isn't any. So that's a problem. The other factor is this. There is no three-strike rule. 3 strikes, you're out, and Sperling proves it.
What's the citation?
What's that?
I can't find this. What's the citation for Sperling?
The citation on Sperling on that is 380 Maryland 180. It's a 2004 decision in which, at the time, it was found by this court and the lower court that there had been negligence allowing a $42,000 shortfall. We're not talking about an $82 shortfall. And that wasn't rectified for 9 months thereafter. There were 3 prior disciplinary cases in that instance. And what did he receive? An indefinite suspension with a right to reapply in 90 days. Because it was a matter of inadvertence. It was a matter of, as Ms. Lawless admitted below, negligence. You could call it extreme negligence. There hasn't been prior disciplinary misconduct of this exact sort, the escrow violations involved. Maybe some of the rules are the same, but we don't have a repeat performance of this specific issue and problem. I recognize that we're not here for the very first time. But if we're going to take that into account as an aggravating factor, which was not found below, the judge didn't even find it worth mentioning in the opinion, then we also have to look at the fact that the judge specifically found no malice, no effort to gain personally as a result of this, and no one has been proven to have lost any money.
You say disbarment is not appropriate. Why isn't an indefinite, flat indefinite suspension appropriate?
Well, obviously that is certainly something that we'd prefer to a disbarment, but I believe that even with a right to reapply in a certain period of time, it's not guaranteed, and the rules make that very clear. So the burden will be upon my client to prove his way back into the practice of law. And I think that one thing that this court can take into account, as you previously mentioned, is how did he ultimately audit and reconcile all of these accounts. Bar Counsel didn't audit the account. Bar Counsel didn't even subpoena all the records. My client is going through them with his CPA to do that. So your question could be very well put upon his motion for reinstatement. What have you done to set this straight? And how have you done it? And show us that either no one lost any money, or if inadvertently they did, it's been refunded. I think that's a very valid question, and particularly on his burden to prove reinstatement. So I don't believe enhanced penalties are appropriate. This court has seen situations where there have been problems in the past. But this is not an instance where you have someone stealing from a client, someone who has lied to Bar Counsel. And all the cases that have escrow violations tied to disbarments have some element of that, which we do not have any proof of in this case. If you look at the Foltz case, hiding funds in the escrow account to avoid judgment creditor. Powell, commingling funds with personal funds with the intent to hide assets from creditors. You've got the Coombe case, 2014, pretty recent, refusing a client's repeated demands for remaining settlement proceeds and willfully failing to account to the client. Friedman, concealing funds, same year, 2014, concealing funds from creditors, including the IRS, by depositing them into the escrow account. When it's unintentional, when there is no showing of willful deceit And there isn't in this case. And by the way, just to answer Judge Houghton's observation, Mr. Miller did not testify that there was a negative balance. If Your Honor looks at that very scant 52-page transcript, you will see that he says, I had questions. He never testified to an opinion, expert or otherwise, that there was in fact a negative balance. He just said, I had questions as he's reviewing Exhibit 30 with the court. And there was an objection to his testimony. At page 17 of the transcript, you will find that my client specifically objected that he has not been qualified as an expert. Ms. Lawless responded, I'm not calling him as an expert. He's a fact witness. Well, I don't know about you, but I don't know how he's a fact witness. He wasn't in Mr. Mahone's office. He wasn't doing any of these transactions. I don't know how he's a fact witness. What he had were questions, and all he testified to were his questions. He provided no answers, nor could he because he wasn't called as an expert. It may well be with his background, and he has a fair amount of forensics and accounting background, that he could have qualified. But that was never done, and he wasn't presented that way. So there isn't any evidence of that sort. As far as responding to Bar Counsel, there was not one but two unclaimed letters in this particular case. And I can't piece together perfectly, why it is the letters were sent to the wrong address, even after the right address was on some letterhead provided to Bar Counsel. But what I can say is there was obviously a communication failure. It's certainly one my client's responsible for, but I don't think we're talking about recalcitrance here. And in fact, if he hadn't complied with discovery to the best extent he could, why wasn't there a motion to compel discovery? There were no such motions because he gave everything he had. And what he didn't have was subpoenaed from the bank, except the subpoena didn't go far enough. If what they really wanted to prove was some true negative balances, you've got to go back before that 4-month snapshot. And that's why I believe the evidence is insufficient to show the type of willfulness, dishonest conduct that would warrant disbarment. I do believe that he ought, consistent with this Court's prior rulings, be given the opportunity to come back. They'll have a burden on that, and that's why I believe he should be suspended and not expelled.
You said he's gotten some accounting help
Yes.
lately. When did he first do that?
I don't have that information with me, Your Honor. But I do know that it was during the course of these proceedings that he did obtain that, recognizing that this is something I've got to take care of. And I know he is in the process of doing exactly that, working with that person. Thank you.